Is there any reason you can't have a civil proceeding running parallel to the criminal proceeding? You know, the state has an agency to allocate fault in the case of auto accidents, you know, and whoever has to pay, you know, and somebody steals a car and, you know, crashes the car and he's criminally prosecuted for that, and in the same accident just has to go through a civil process where he may also be assessed a fine. Is there anything wrong with that?
No, I think Congress could have chosen to do something like that. Now, depending on how it was structured, that may raise some serious problems under the Seventh Amendment. But putting the Seventh Amendment consequences of such a scheme aside, Congress might have created such a system, but that's not what it did here.
Could it just say, we intend this to be civil and have the operations of the statute operate in the same way, and then we would say it's civil? In other words, it seems odd that so much turns on the label as opposed to the operations of how the statute works.
Well, I think if Congress perhaps just said the word civil but did everything exactly the same, we would still be before you arguing that that is quintessential criminal punishment. But this court has said that the inquiry at the first step of the criminal punishment—
Quintessential why? If it's payment to the victim, just like a tort suit. I know some of the folks have characterized this as just a tort suit-like.
Sure. I think if it's still part of the sentence that is imposed by the sentencing court as part of the sentence, together with imprisonment, fines, probation, all of the other criminal punishments, I think our position would still be that is criminal punishment. But Congress could have written a different statute that would have accomplished something civil, again, wrestling with the Seventh Amendment consequences of that. The Seventh Amendment is, I think, important here because it is part of the backdrop against which Congress legislated in the MVRA. In the wake of the VWPA, which was the predecessor to the MVRA, the courts of appeals uniformly rejected Seventh Amendment challenges to restitution on the ground that restitution is criminal punishment. This court commented on that uniform consensus in Kelly versus Robinson before Congress enacted the MVRA. This court also construed the VWPA in Huey before the MVRA and applied lenity to the VWPA as a criminal statute. All of that is part of the backdrop against which Congress enacted the MVRA. And not only did Congress not do anything to signal it was intending to depart from that consensus, but it carried forward the same operative language from Section 3663 in the VWPA.
And in its legislative history.